Welcome to Estate Planning Beyond the Binder.
Welcome to Estate Planning Beyond the Binder with Brian Chu, Managing Attorney of OC Wills and Trust in Orange County, California. For more than 25 years, Brian has helped individuals and families create customized estate plans designed to protect their assets and provide clarity for the people they love. I'm LeAnn Lyon, and today we are talking about a law that has significantly changed estate planning for California homeowners, Proposition 19. Hello, Brian. It's good to see you again.
Great to see you again, LeAnn. Thank you for having me on.
Brian, what is Proposition 19 and why did it change estate planning so dramatically in California?
Well, first of all, it's a quick background here. In California, as most homeowners are aware, we have Prop 13 effect. And Prop 13 basically says when you buy a home, your property tax is based typically on the value that you paid for it. No matter how much the value of the house goes up in value over the course of the years, your property tax can only go up 2% per year. Okay. Unlike other states where they reassess the value of property every year, we don't do that in California. So we have people, we have people that have owned property since the 70s whose property taxes are based on more or less the value of what they purchased it for in the 1970s.
Wow.
And so we have a lot of people who are paying very low taxes on their property taxes. And under Prop 13, they'll also allow that property tax base, this low property tax base, to be passed on to your children under certain circumstances. And under Prop 13, it used to be no matter how much your house went up in value, if it was your primary residence, and if you pass that on to your kids, your children, or even grandchildren potentially could continue to keep that low tax base. So even though we're in 2026 now, they still might be paying tax based on the 1970s values. Okay. Also, they could also pass on another $1 million of other property, increased value, at the low property tax basis as well. So it'd be a rental property or some other property could be passed on. Well, we voted for some reason to tax ourselves with Prop 19. It was enacted a few years back. And basically that said, it took away almost all the exemptions for the transfer of the property tax basis. The most commonly used exemption now is when somebody passes away, or any kind of transfer, even if you give the property to your kids, is in order for that low property tax base to pass on to your kids, a couple things have to happen. It can only be your primary residence. So it has to be the house you live in. So no more rental properties, right? Vacation homes or anything like that. The only property that qualifies for the transfer, the exemption, is your primary residence. It can be passed on to your kids, but the property tax base only remains the low property tax base for as long as one of your children remain in the property. They make it their primary residence. All right. So even if they get the property and they move out, then the property taxes will go up. Okay. So they have 1 year within the time of you passing to move into the property. To some extent, it doesn't necessarily affect like how you would set up your estate plan. Necessarily, you're probably still going to go 50, especially if you're doing everything equally to your kids. But it would affect, if you have 2 or 3 properties and you have 2 or 3 kids, it might affect if you decide you want to give property A to child A and property B to child B. It does affect the value of the property. Property A, if that's your primary residence, and they're to make it their primary residence, well, that property's worth, more than just what the property's normally worth, because the property taxes would be artificially low. Whereas the property, the B property, which you didn't live in, those property taxes would go to full market value. And that's what Prop 19 does. Prop 19 says the property will be, if that child doesn't move into the primary residence and make it their primary residence within a year of your passing, the property is going to be reassessed to full market value, which in California can be tens of thousands of dollars higher taxes as a result.
Wow, that is fascinating. So, what happens when a family transfers a rental property or vacation home now under Prop 19? Is there any property tax protection left?
Unfortunately, no. And that's where the big shock comes. All of a sudden, they were paying, $5,000, a year for property taxes. Now it's $15,000 a year for property taxes. And so the big decision then for something maybe they were going to hold as a rental, and it made a lot of sense, maybe it doesn't make as much sense now. And now they're maybe forced to sell the property. And coincidentally, that's the realtors are the ones who back this law, and that's not a coincidence.
Mm.
Uh, and so that's the issue is that the property or even the primary residence. A lot of times, oh, the kids. Maybe it's the primary residence. They wanted to keep it as maybe a place where the family, the families even could go from time to time and enjoy it. Because it's nobody's primary residence, the property taxes are going to go up on that property. Or, if obviously they're going to rent it out or anything like that, then the property taxes are going to go up. And it just makes it much less the much less attractive for somebody to hold on to the property, perhaps.
So, can you walk us through a real world example where a family assumed they could transfer a home the way they always had, but Prop 19 created a much higher property tax result than they expected?
So let's say it's that even if it is their primary residence, especially here in Orange County and other parts of California. The other thing I didn't mention about Prop 19 is that it used to be unlimited, the amount. So if the house went from, and this is very common, went from 500,000 to 2 million, there would be no reassessment. Okay. But under that scenario, the limit actually is only the first $1 million is not subject to reassessment of increased value. So if it went from 500,000 to 1.5 million, okay, and it's a prime residence, they wouldn't pay any additional tax. Okay. But if it's gone from 1.5 million or 500,000 to 2 million, now they will pay another 5,000 or so more in taxes because they had $500,000 more increased value that was not exempted.
Mm.
Uh,
Yeah.
so even on a primary residence, there can be, and this is very common in California. We've had people that paid 50,000 for property is worth a million, or I mean more than like 1.5, 2 million. What otherwise would have been exempt before under the old law, they're now have to pay higher taxes. Obviously, on a rental property, it's even worse because again, there is no $1 million exemption. It's 100% reassessed. And so again, that example, even it's, they paid 100,000 for it, it's worth 1 million, which again, not that uncommon. They're paying, 10 times more taxes. And that's, that for a lot of people, that could be pretty massive. And it's one of the unfortunate consequences of how our current laws are now set up.
It sounds complicated as well, as if there might be more reason for people to be really carefully understanding this as opposed to the relatively simple system before. So, how does
Yeah.
Prop 19 affect trusts specifically?
Obviously, when you create a revocable trust, nothing's really changing. So, you putting a property into a trust doesn't change anything about your property tax basis. That remains the same. I think it's more on the planning side, in terms of, again, especially if you're going to designate certain properties to go to a specific child, it does affect the value of the property beyond, the normal appraised value of the property because of the potential for the lower property taxes. But I'd say the biggest overall estate planning issue that comes up, it's not even so much an estate planning because it's while you're alive. People have done things that are sometimes hard to undo, like they put kids on title after they purchase the property. And maybe now the kids are contributing to the property in anticipation of them getting it one day. And they now want to change, the titling of the property from joint tenancy to something else. And that might trigger reassessment. So there's all kinds of transfers that otherwise would have been, because it was parent to child, wouldn't have been subject to reassessment while they're alive that can trigger reassessment while they're alive. And we see it, unfortunately, happen a few times where somebody, what they otherwise thought really didn't change anything, ended up triggering reassessment all because of the history of the property, of who bought it originally and who was put on title when, and now they're looking to change it. That can have a drastic effect on the property taxes unknowingly.
So, for families in Orange County with highly appreciated homes, how significant can the reassessment impact be in real numbers?
Again, I was explaining, that, if your parents, let's say, $500,000, again, especially on a rental property, that property taxes might be, five, six, $7,000. And let's say that property's worth $2 million. Well, now the property tax is gonna be $25,000 perhaps. Okay. And so obviously that's a massive increase in the taxes and, not uncommon. And obviously, if, that obviously gives you some incentive, whether you like it or not, maybe it's, for, $20,000, it might be worth moving it, a year, it might be worth moving into the property, even if that's not the place exactly where you want to live. Especially again, if you want, if you don't want to sell the property, but that's, ultimately that's unfortunate. What it forces a lot of people to do is, when they inherit the property, the rental option is as attractive now. So yes, then the option then is to sell the home at that point.
So, as we wrap up today's episode, and this is for homeowners who are unsure whether their current estate plan accounts for Prop 19, what steps should they take to review or adjust their plans?
I mean, again, when it comes to estate planning, I think it's mostly, if you're allocating specific properties or bequesting specific properties to, different people, just realizing that the simple appraised value of your asset, of that asset, can change as a result of the Prop 19, or, in real life be different just because of the property tax. And that may or may not have an effect that may make things more or less fair. And so that would be, I guess, the number one consideration. I think the other one is really, it's those people that aren't going to do estate planning, that are going to try to do changes with title changes, joint tenancy, and things like that, or going to give some of the property to the kids while they're alive. That's where you've got to be very careful about those things. So it's not as much of an estate planning issue as like I said, if you're going to do something different with your property, you want to make sure it's not going to affect your taxes today.
Well, thank you to our audience for listening to Estate Planning Beyond the Binder. Proposition 19 has reshaped how property transfers work in California, especially for families hoping to preserve a low property tax base. If you own property in California and want to make sure your estate plan reflects the current law, visit ocwillsandtrustattorneys.com to schedule a consultation. And if you found this episode helpful, be sure to like, subscribe to the show, and share it with somebody else who should hear it. Thank you, Brian.
All right. Thank you, LeAnn.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.